So what we're looking to do is tighten the language of neglect so that we essentially give parents their parental rights. You know, we concentrate them back. We need to we like the federal definition, again, not adopting federal code, but the federal definition. And so if you will look at the stuff on your handout, you'll see that the 691 changes the definition of neglect to add specificity. Okay, as it stands right now, it's incredibly broad, and it's currently defined as a child who is without proper parental care or control or substance necessary for his well-being. So what's happening, and I ask you to consider your own children or your grandchildren. I mean, this has been used so broad that they could be out on a country road, on a bicycle, no helmet, without parental supervision, and, oh, well, they could get hit by a car. Maybe they missed a meal. I mean, literally, the definition we currently have is so broad that it's way off the federal definition. As you'll see, the federal definition asks that things must result in death, physical or emotional harm, physical or sexual abuse or exploitation, or an act by a parent that presents an imminent risk of serious harm to the child, or a parent is unable to discharge their responsibilities, and that inability and the child has been harmed or is likely to suffer imminent serious harm. So we're changing the definition from this broad, you know, kind of vague out there definition that the state of Idaho has used to the federal definition. And I'll also point out that a heck of a lot of states are going this way, and if the federal courts are already using this language. And so, Mr. Chairman, if I could, I would like to cede the rest of the opening to Mr. Scott Herndon. And this is something also, as I started working on this, I was reminded that he's a little more of an expert on it. And so if we could call him up, and then we'll certainly answer questions. So thank you.
And it looks like we're connected. Mr.
Thank
Herndon,
you.
thank you. Come on and introduce yourself.
Okay.
Tell us who you are and what you know.
Yes, thank you, Mr. Chairman and members of the committee. My name is Scott Herndon, and I am from Sagal, Idaho. And I want to talk about what changes are being made in House Bill 691. And my history with this goes back to about 2018 in the Idaho legislature, when I was just a citizen back before I was in the Senate. We ran several bills related to child protective services, and actually we looked back then at the definition of neglect. I don't actually remember which session it was in the Idaho legislature, and we started contemplating definitions of neglect. And the reason that we did that at that time is there were states that were moving to change the definition of neglect due to the number and the volume of cases in CPS. So I want to talk about what House Bill 691 does and the careful crafting of exactly what is changing. So first of all, what is changing is just the definition of neglect. And right now, the definition says that it's a child who is without proper parental care and control or subsistence necessary for his well-being. That is considered a very broad definition of neglect. And so what that results in is it results in about 22,000 cases are called into CPS every year. I put a statistic on your sheet about the middle of the page that in 2022, Idaho CPS received calls for child abuse or neglect, and there were 21,200 calls. And it turns out, while most people think of CPS mainly related to abuse, the majority of the reports are for neglect of some type. In that year, 73.6 of cases called in were for neglect. That's actually quite common in Idaho. If we look back several years before that, it's always around 70% or so. It's also the same statistic nationally. Now, as a result of that, over the years, Idaho typically sends out CPS caseworkers or investigators to about 10,000 of those calls. So what they do is they prioritize those calls that come in, and they decide which ones need a caseworker assigned to it. When they do those investigations, if we use a round number of 10,000, it turns out that 80% of the time, and this is also the nationwide average, 80% of the time the alleged conduct or the claim of neglect is found to be unsubstantiated. So in a typical year, thousands of families in Idaho will receive contact from CPS caseworker, and it turns out that after the investigation is complete, there was no conduct or no neglect found that was substantiated, and the caseworker goes on their way and the family goes on their way. But that is a lot of people being investigated yearly by Idaho CPS. What the bill does is it changes the definition very precisely. It takes away the lack of specificity, and it adds a lot of clarity to the definition. It does the following. It says that it's got 3 key points, and this is all on page 4 of the bill, and it's in the middle of the page. Under subsection 3, you've got a 1, a 2, a 3, a 4, and a 5 under there with the Roman numeral system. And the first one basically says that the neglect must have resulted in death, physical or emotional harm, physical or sexual abuse or exploitation. The second one says an act, and so this is an or. In each of these cases, it's either the first one or second one or third one. Or an act by a parent presents an imminent risk of serious harm to the child. And then you've got an or. A parent is unable to discharge their responsibilities, and the child either has been harmed or is likely to suffer imminent serious harm. What it doesn't do is it doesn't change the last 2. A child who is without proper education is defined by 33-202. That stands completely on its own, so the educational neglect standard will remain exactly the same. It's moved from page 5 to page 4. And it also says that a child who's been placed for care or adoption in violation of law will continue to be a neglected child. We don't change that at all. Here's the reason we want to make the change. We want to make sure that we cut out all of the unnecessary reports to CPS so that the resources are only focused on those children who are being harmed. So right now, you could call in and you could say, well, a child doesn't have enough milk in the refrigerator, or they have orange juice versus apple juice, or they get too much TV or not enough TV, or they get too much time outside or not enough time outside. Literally, the definition of neglect is so overbroad right now that we want to add specificity. And the other reason we want to do that, number one, to save CPS resources for the kids that are actually being harmed or could be harmed. That's also in this. We want to also prevent the state from harming the children. And that's another part of the case we want to make for this bill, that when the state investigates children, it's on the 3rd page of your handout, there is a book called Storming the Castle to Save the Child, and it's often quoted by the Ninth Circuit Court of Appeals. It turns out that when the state investigates families, it actually causes harm to the child and even to the parents. And so we want to reduce that harm. And you can imagine when law enforcement shows up on your door with a CPS caseworker and then completely invades the privacy of your household, that creates a problem. We are matching the definition to the federal definition in the Child Abuse Prevention and Treatment Act. And it also matches a lot of case law on this subject. There's no doubt that the federal courts have weighed in and said the only time you can even remove a child from a home is either you have a court order, meaning a warrant, or you believe that there is such imminent serious harm to a child that in the time that it takes you to go get the court order, the child would be harmed in that time. And so we're taking the definitions right from federal code, U.S. code. We're not the first state to do this either. A number of states have already moved forward in this direction, including Texas, Utah, and Illinois, and all of them use this language. They basically rely on the federal definition of actual harm and immediate danger in Texas, risk of harm in Utah, and serious harm, blatant disregard, and obvious danger in the statutes in Illinois.
Scott,
and with that,
Scott,
Mr. Chairman, I'm happy to stand for questions.
Great, thank you. Do we have any questions? Nobody?